Chancellor and Provost, Vice Chancellor of Health Affairs, CO, UCI Irvine, Dean, UCI School of Medicine, and other members of the School of Nursing, School of Medicine, and UCI Center for Senior Management. He is the de facto go-to person at UCI. He also advises the Student Health Center and Counseling Center on the UCI main campus. He is a member of the Hospital Executive Leadership Team, Governing Body Advisory Committee, Medical Staff Executive Committee, Medical Staff Credentials Committee, and the Risk Management Committee. Mr. Schneider supervises one attorney and one staff member in the Office of Campus Counsel, and also oversees the Medical Center's Risk and Regulatory Affairs Department. His practice includes state and federal regulatory issues, including reimbursement and fraud and abuse analysis, group purchasing, joint ventures, and affiliations with various entitled entities. Privacy, physicians' discipline, and medical staff matters, credential issues, internal and external investigations, acquisitions, medical center, and School of Medicine strategic planning and faculty, residents, medical students, related matters. Before joining UC Irvine, Mr. Schneider was University Counsel in the University of California Office of General Counsel with primary responsibility for legal oversight of the UC Hospital and Professional Medical Liability Program, involving its 5 medical schools and teaching hospitals, 2 affiliated county hospitals, student health centers, and all faculty and residents as well. He was also responsible for initiating a system-wide medical risk management committee of medical directors from all facilities to concentrate on systemic sharing of risk reduction strategies implemented by the campuses. Prior to joining the University of California, Mr. Schneider was in private practice as a partner at Bond Bridges, Mueller, O'Keefe, and Nichols in Los Angeles, and Thomas Mort Prosser, and I'm not sure if I'm pronouncing this last name right, Knudsen in Riverside. So please, everyone, join me in welcoming Mr. Schneider today.
Thank you, Reese. Thank you, Kelly. Am I able to share, Kelly? Okay, let's see if we get this right. Hello. Okay, the title of this conversation, everybody, is called Physician Beware, Malpractice Insurance, Kickbacks, and Things That Might Make You Lose Sleep at Night if you weren't listening to this presentation. You will sleep much better after listening to it. We'll take questions at the end. It's going to be chock-loaded with statistics and some war stories. And as you're thinking of the war stories that I'm going to tell you, I want you to realize that these things really happened to people just like yourself. Highly qualified, well-educated, careful individuals. So let's start with some basics. What is medical malpractice and malpractice litigation? What's being done about it? And how do we prevent it? And I said sort of, because it's like complications in medicine. You can prevent much of it. You can try to be careful about it, but you're never going to prevent all of it. So let's start with the definition of medical malpractice. And we find that definition in the jury instructions, so that if any of you are ever sued, at the end of the case, the judge instructs the jury on the law that they need to apply to all of that testimony that you've heard. And this is what the judge tells the jury. We'll just say a physician is negligent if he or she fails to use that level of skill, knowledge, and care in diagnosis and treatment that would other reasonably careful physicians used in the same or similar circumstances. So important words, same or similar circumstances. This level of skill, knowledge, and care is sometimes referred to as the standard of care. The judge goes on to tell the jury that you must determine the level of skill, knowledge, and care that another reasonable, careful practitioner would use in the same or similar circumstances, based only on the testimony of the expert witnesses who have testified in this case. So first and foremost, the only individuals who can prove that another physician has committed malpractice are other physicians. And I would joke, look to your right, look to your left. One day you all could be sitting in judgment on each other. That shouldn't make you hesitant to call something that you feel is negligent. But it is a caution that ask yourself, there but for the grace of you know what, go I. Again, it's not the courts that impose malpractice judgments. It's not the juries that simply don't get it. It's physicians testifying against other physicians. Without it, juries would have no basis to find liability because juries, or at least most juries, simply do not understand the technical aspects of medicine, notwithstanding WebMD and every other website. What about hospitals? Most physicians aren't employed by hospitals, but a hospital, and by that we mean the medical staff, is negligent if it does not use reasonable care to select and periodically evaluate its medical staff to make sure that the patients are provided adequate medical care. Most of you are matriculating or have matriculated through UCI. And when you reach the stage where you have completed residency, maybe you're going into a non-ACGME fellowship, you will need to get medical staff privileges. And you'll need to attach your CV. You'll need to prove that you are competent in a variety of procedures, things that we call core privileges. And then the medical staff will put its seal of approval on you. But you're going to have to do that roughly every 2 years. And you're going to have to meet what is generally not a static set of criteria every 2 years for the hospital to allow you to do certain things in its licensed space. That's the process we call credentialing and recredentialing. And if the hospital doesn't do a good job of this, the hospital can be sued if a patient gets hurt by a physician. So when you read in a newspaper that a physician lost medical staff privileges and sued a hospital for $50 million, claiming that this was part of an attempt to keep the physician from practicing, or it was a hospital trying to strangle who could practice and who could not practice, you need to read a little further in the article to see what was the physician accused of. There are cases throughout the country where we have physicians whose complication rate can be unacceptable. Now, an unacceptable complication rate to a group of peer physicians may be 3 or 4 out of 100 procedures in a year. To lay people, it doesn't sound like a whole heck of a lot, a 3% error rate or a 4% error rate. But if statistically the error rate of a procedure is 1% or less, and you have a physician who's got a 4% error rate, well, maybe your credentials committee needs to take a closer look at those cases and determine whether there is a pattern going on. This peer review occurs throughout the country at every hospital all the time. It is a requirement of California law in Title 22. It is a requirement by the Joint Commission and by Medicare, by CMS. So we all engage in that all the time. And if we don't do it well, we get sued. So when we talk about malpractice, what are the types of errors that we deal with? Heading number one, I would call diagnostic errors. Error or delay in diagnosis should seem fairly obvious. The failure to employ indicated tests. Are you doing the right diagnostic tests? Are you employing the correct screening exams? The use of outmoded tests or outmoded therapy. You all will have a continuing education requirement. There is a reason for that. Science moves at lightning speed. I wonder how many of you thought 1 year ago, to the extent you were at this presentation a year ago, that in less than 1 year, we would have a vaccine, more than one vaccine, against COVID-19 that was 95% efficacious and had been given to tens of millions of people in the US and throughout the world. It's because the science, the technique, the instrumentalities are coming out with breathtaking speed. You know, we'll talk about artificial intelligence a little later on, that you will need to be up to date so you don't get in a situation where you use outmoded tests or therapy. Failure to act on the results of monitoring or testing. We'll unpack that a little bit. So what's an example of a failure to act on results of monitoring or testing? Let's say you have a situation where you are in the community and you refer a patient to a major center for the type of MRI that you cannot just get at your local radiology group. And you're concerned about something that you may think is going on. You may be looking for cancer, you may be looking for something else. You send the referral over. You make sure that the patient got a copy of the referral, and you tell the patient it is the patient's responsibility to actually set up the appointment. And then you don't see the patient for a year. And then the next thing you know, the patient is in the hospital with the advanced stages of some terrible disease. And you might say to yourself, well, it was the patient's responsibility. I told the patient where to go. I sent the referral through the system. I made sure it got to the end location. And the patient never called me back to set up an appointment. Logical, right? With a busy community practice or any location. How do we keep track of every patient who we refer out for any kind of diagnostic imaging or other kind of testing? And even if we've made the appointment for them, how do we know that they've had the test? What is our obligation to reappoint the patient for follow-up? What is our obligation to have a tickler system in this era of computer to follow up with the patient or to follow up with the radiologist or to follow up with the lab? Has the patient come in? If the patient came in, why don't I have a result? If I have the result on top of a chart somewhere in a pile of lab results that have come in, how come nobody in my staff has associated the lab with the chart and put it on my desk with a big red tag that says review? These are the kind of things that have gotten physicians in trouble that we would group under the heading of failure to act on results of monitoring or testing. You need to have a system within your practice. And I know it's going to be hard if you're in a big group practice because you don't control everything, but you need to make sure that the group has a way of tracking referrals for diagnostic testing, of following up with patients. Did you make the appointment? When are you being seen? I want to see you within 2 or 3 weeks of you having the test. We're going to call you. We're going to follow up with you. And oh, by the way, if I don't have the result, we're going to follow up and try to get the result. The life you save will be the patient's, and the mental life you save will be your own. Let's go through some more types of errors. Errors in treatment. An obvious one, error in the performing of an operation or a procedure or a test. And these often are expected risks and complications, but not always. Laceration of a vessel, damage to adjacent structures. You name it, it can happen, but it can be the basis of a malpractice case if, look to your right, look to your left, if the person sitting next to you would say that in the hands of a well-qualified physician, this error, while it theoretically can occur, should not have occurred. Error in administering the treatment. Error in the dose or method of using a drug. Think of all the new compounds that are coming out. Think of when we have designer medications that are made up in pharmacies for specific uses, and we're compounding them. Think of how we're doing the math, and I realize you have to rely on the pharmacist and sometimes the nurse. Lots of different things that can go on. Avoidable delay in treatment or in responding to an abnormal test. You know the patient needs surgery. You submitted authorization to the insurance company. You submitted it on a stat basis. And then do you forget about the patient? Do you tell the patient it's their responsibility to follow up with the insurance company? 1 month goes by, 2 months goes by, you haven't heard from the insurance company. Have you followed up? Because there's a reason you submitted a stat authorization to an insurance company. Are you working with your patient to clear payment? These are all things that can get you into trouble if you're not on top of it. The last category, inappropriate or care that is not indicated. It happens sometimes. There are people out there who will operate and have their judgment clouded by economic gain. You have a population that puts a tremendous amount of trust in you. You have to be true to your calling and not recommend care that truly is not indicated or only possibly indicated when there could be a profit motive. So let's talk about error in administering treatment. Let's say you order a medication that has to be compounded. And let's say that the people who are compounding it are going to have to do some math because the route of compounding, which is usually intravenously, is going to be intrathecally. Fairly unusual. And then let's say you're simply handed a syringe days later and you start the intrathecal injection and it's the wrong dosage. The dose that's on the label is the dose that would have been used for an intravenous injection. Are you responsible? Can you say, well, the pharmacist gave it to the nurse gave it to me. It's not up to me to check the label and confirm that what I am seeing in the syringe is exactly what I ordered. Medicine has lots of redundancies built into it. But every once in a while, and you've all heard about the Swiss cheese theorem, where the holes just line up, something just lines up because you get things called confirmation bias. The ordering physician is relying sometimes on technology and assuming that the compounding pharmacist gets it right. The compounding pharmacist is assuming that the redundant pharmacist, the checking pharmacist, is actually going to check as opposed to assume. The nurse isn't checking the label provided by the pharmacist because, of course, the pharmacist is reputable and the pharmacist never makes a mistake. And the physician doesn't look at the label because, of course, the nurse is the final patient advocate. And all of a sudden you have a patient that has received the right medication in the wrong dose for the wrong administration route and a potential disaster. The way to prevent this, your practice tip, never rely on somebody else. You have two eyes. You as a physician are the final guarantor of what you're given. If you're operating, you would ask for a certain instrument, but you would look at it before it touches skin. You have to do the same thing here. Error in dose or method of using a drug. For those of you that are in training programs, the attending issues an oral order for a certain medication. The fellow gets the oral order over the phone. The fellow is training a junior resident. The junior resident then transmits it to the intern. The intern thinks the intern heard it correctly and enters it into the EMR accordingly, where it goes to the pharmacy. And how about everybody thought they were doing the right thing, but a decimal point was misplaced in a classic situation that we used to call telephone when I was waking up or growing up. All of this is considered an error in dose or method of using a drug that can be in normal dosages relatively harmful, can be extremely toxic in the wrong dosage. And everybody up the communication line is pointing a finger and saying, in all honesty, well, that's what I thought they told me. Double check. Confirm. Even in an era of electronic health records, decimal points can sometimes be misplaced. That's why we always ask for the 0 point rather than just the point. Okay, really important. Another category of errors, the preventative errors. Failure to provide a prophylactic treatment. Inadequate monitoring or follow-up of treatment. We're never done until we're done. Failure of communication. The communication can be written, the communication can be oral. Double check, triple check if you have to. Think about pilots in the cockpit. And we've all seen it on TV. The pilot will tell the co-pilot something is indicated. The co-pilot will look down and say, verified. Always verify. Equipment failure. There's often nothing you can do about it. All you can do is make sure that you've checked the equipment. And that includes sometimes confirming with nursing that all of the equipment that you need is actually on the cart. If you're doing orthopedic procedures and you don't have all the equipment that you need, if you don't have the right size reamers and you've opened up the patient and the bone is sticking out there, what are you going to do now? Make sure that you've got all the right equipment. And then, of course, there can be other system failures where you're effectively a victim. You're caught up in it. The computer didn't work right. The computer didn't translate right. Uh-oh, somebody did cut and paste and I didn't independently verify. But these are all of the things that can work against you in the clinical setting. You don't have to take my word for it. Lucian Leap and others identified all of these way back in 1993, but they hold true today. So what does our healthcare culture produce? And when I talk about our healthcare culture, I do it with tremendous admiration. The things that we in US healthcare can accomplish are the envy of the rest of the world. Pre-COVID and during COVID, people come here from all over the world because we can offer things in terms of expertise, in terms of protocols that no other country can offer. And yet, with all of our expertise, with all of the safety features we have, with all of the redundancies we've built, there are 44,000 to 98,000 deaths a year due to medical errors, according to the Institute of Medicine. In 2006, over 40,000 instances of medically induced harm occurred every day in the US based on survey. The healthcare employee injury and illness rate pre-COVID was over 8 per 100. That's an 8% injury and illness rate in healthcare. Compare that to construction, which is lower. And in 2009, in the US, there were $8.6 billion of professional liability claims against physicians, nurses, advanced practice practitioners, laboratories, and the like. All of the things that this culture is producing, when it goes wrong, can be very expensive. And I know that the things that I see are the fraction of a percent of times when things go wrong. And I know 99.999, et cetera, percent of the time, we who are not in the OR, who are not in the clinics, don't see all the things that go right. But $8.6 billion in 2009 are a boatload of medical claims in this country. This article came out about 1.5 years ago, and it is really interesting and really well documented. And it was just dealing with our misdiagnosis theme that we talked to above. And it focused on 3 main areas: vascular events, infections, and cancers. Those are the big areas of vulnerability. And if we look at this highlighted paragraph, it's worth reading. Autopsy detected error rates and total hospital deaths suggest 40,000 to 80,000 misdiagnosis related death in US hospitals annually. Estimates from national malpractice data suggest that serious morbidity is at least as common as death, translating to roughly 80,000 to 160,000 serious misdiagnosis related harms each year. Don't forget, now we're dealing just with misdiagnosis. We're not dealing with injuries to adjacent vessels. We're not dealing with positioning injuries. We're not dealing with the myriad of other things that can go wrong. Just misdiagnosis. They extrapolated from that the diagnostic error rates in specific studies suggest that 12 million Americans suffer a diagnostic error each year in primary care alone. I don't know if those statistics were sobering to you. They were pretty sobering to me because I've been blessed to work at the University of California and in the healthcare enterprise for 22 years. And I think we render world-class healthcare that is remarkably safe. We give hope to people who don't have a lot of hope. And we do a pretty good job on the more routine stuff too. But 12 million misdiagnosis-related victims in the US on a yearly basis is just whopping. Tough profession. And that's why we have to continue to build redundancy into it. We have to continue to be super careful. It's why it's going to continue to be exhausting, but rewarding. So let's look at the National Practitioner Data Bank statistics through 2014. You get reported to the National Practitioner Data Bank if a settlement or verdict is rendered against you and you are deemed to be responsible in whole or in part for the settlement or the verdict. I took a look at 3 states, all with different cultures. So California, between 2004 and 2014, we had approximately 143,000 physicians, 38.8 million in population. Obviously, we have more physicians and more millions of population. During that period of time, we had 12,000 reports to the data bank, which is about 1,200 a year. And you might say, that's not too many. Let's look at Florida. About half our population, about half the number of physicians. Not quite, a little more than half of the data bank reports. Florida, among other places, is very pro-plaintiff attorney oriented. Their malpractice premiums are among the highest in the United States, especially in the high-risk specialties of neurosurgery and OBGYN. They do not have limitations on damages, but they're getting approximately the same percentage of data bank reports. And let's look at Texas. Texas is very defense-oriented, very conservative state. They don't like lawsuits. But you know what? A little bit of a larger population than Florida, much less than California, a little more than half the same number of physicians, but they're trending the same way. The only conclusion that you can draw from that is it's not so much the laws in the state. It's not so much the environment of whether it's really friendly to physicians or friendly to the lawyers who want to sue physicians. There seems to be a relatively constant error rate, and that's entirely consistent with the statistics and the study. So while you might think you're a sitting duck in Florida because of the malpractice, the lack of malpractice caps, the high malpractice insurance rates, you're not theoretically any safer a physician if you're in Texas or if you're in California. 3 big states, 3 different cultures, 3 different legal systems, fairly consistent rate of National Practitioner Data Bank reports. So when the HITECH Act was passed in 2009 and we were all going digital, digital was going to prevent malpractice suits. It was going to be the answer to everything. As the article that you'll see the site to indicates, after $36 billion in 10 years, it's been a little less than advertised. Article appeared in Fortune on March 19, 2019. You can look it up on the internet if you'd like. 5 key takeaways. The EHR has created a host of risks to patient safety, tied to software glitches, user errors, or other system flaws that have piled up. As of literally today, there is no central database which exists to compile and, study the incidents to improve patient safety. The risks of fraud. The software can be misused to overcharge. The practice that everybody in the industry knows is upcoding. Before you say, gee, upcoding doesn't take place, it does. The Office of Inspector General and the U.S. attorneys are all over it. One of the ways one looks at upcoding is the reimbursement related to COVID treatment and COVID deaths. All right. COVID is coded differently than a regular pneumonia. This is the EHR at work. There are gaps in interoperability. Only now are we beginning to get to the point where different hospital systems can talk to each other. You still have a problem talking to somebody in another state. You may have trouble talking to somebody in another county because there are multiple EHR systems. Not everybody is on Epic. We're making progress, but it still may be that you can't access certain patient records, and this can affect treatment. One of the things I still hear a lot about, it's better than it was 3 or 4 years ago, is physician burnout. I can tell you when I was in my 20s and I needed to see a physician who had a paper chart, I didn't remember seeing a physician jot down too many notes, a few lab values, history as I was speaking. Other than that, the physician wasn't writing too much in the chart until after the appointment was concluded. Now you're writing in the chart during the appointment. You're writing in the chart after the appointment. You may have charts piling up that you need to authenticate well after your clinical day has closed. And people are wondering, with some reason, whether the EHR has made their practice move faster and safer, or just added 2 hours to their workday to navigate drop-down menus, delete words that were dictated that are mangled, all of those kinds of things. Very, very different. And then, of course, the companies that supply the latest and the greatest software. You will probably not have to deal with software licensing contracts, but they're every bit as closed as the Fortune article suggests. The information flows in one direction, and there's not a whole heck of a lot one can do about it because the intellectual property itself becomes very valuable. So for those of you who have recently matched, congratulations. Now that you know what specialty you're going into, let's see what percentage of your working life you will spend involved in malpractice suits. This is a study done by Seth Seabury that was published in 2013. If you ask people anecdotally, does it make sense? If you talk to the attendings, they'll say, yep. So the light blue or turquoise are the claims where there was no settlement or verdict. The red is the claims where you just had to spend time defending it. And you will see that, for instance, in neurosurgery, 27% of a physician's working time over the life of their practice was spent at least in neurosurgery, involved with a malpractice claim. Boatload of time. Then our colleagues in psychiatry, significantly less so. For those of you, whatever you've picked, take a look. I hope 40 years from now or 50 years from now, it will turn out not to have been the case. But Seabury's study was quite robust in its database. So we touched a little bit on Florida, Texas, and California state tort reform, which are ways that don't lower the risk of malpractice, but they do lower potentially the cost to the physician of malpractice insurance. Right now, we have 33 states that have passed some form of malpractice reform. In California, it's something called MICRA, which many of you may have heard of. It limits pain and suffering damages in California to $250,000. That has been the limit since 1976. There's no inflation escalator built in. We all know that $250,000 in 1976 bought a lot more than it does in 2021. However, all efforts to get that cap raised have met their doom either with the legislature or on statewide initiative. Two of the states that had originally passed some level of tort reform, Illinois and Florida, as I mentioned, they had it invalidated and it's not there. Remember, tort reform does not prevent malpractice. It just makes insurance a little easier to afford. So there was an old movie called War Games, came out in 1983, and it was one of the first movies about computers potentially getting us into thermonuclear war without human beings being involved at all. If you've never seen it, it's kind of fun. But there's a line there that resonates when you think about malpractice. And here it was talking about what the computer simulation was doing. And the computer concluded that the only way to win thermonuclear war was never to engage in thermonuclear war. And that goes for malpractice. The only way to win a malpractice case without going through all the grief we've talked about is not to get sued. So what do we need to do to avoid getting sued? Document. You've heard the saying, if it wasn't said, it wasn't done. Believe it. If it's not in the record, it's going to be awfully hard to prove it. It can be in a handwritten record. It can be in a typewritten record. It's got to be in the record. Consent. How are you treating consent? Are you treating consent as a conversation with your patient where you actually are looking at them and listening to make sure they understand what you're saying? Is consent a form to you that you just ultimately need them to sign and have it witnessed so one can move on doing what you think is best? Consent, for those of you that were in my presentation during your third year, you know, is a conversation. It is a meeting of the minds. It is acutely important with a population that is either overly knowledgeable because they've looked everything up on the computer and they now think they know it all, except they're just missing a boatload of context, and a population that truly doesn't know or doesn't understand. When you're consenting a patient, you must assume that they are 16 years old and have that level of understanding of the terms we use. They do not speak physician. It's not just a form. Are you treating the patient as a person or as a lab result? What if your patient's a physician? Do you assume that they know everything that you're talking about? Do you assume that they've understood it? What if you're the orthopedic specialist and your patient is a 75-year-old family practitioner that probably hasn't dealt with an orthopedic injury since their 4th year of medical school. Don't assume, even with higher levels of knowledge. Treat your patient as a person. Don't treat them as a lab result. Don't assume knowledge or understanding. How is your staff treating the patient? Are they listening? Are they empathetic? If things are delayed, are they communicating with patients? Are they rushing patients through for productivity purposes, or to get to lunch, or simply to protect you? How are you treating your teammates in the OR when you page them? The greatest allies that you have in the OR are the nurses, the scrub techs, your assistants. If you treat them well, they'll treat you well. Because if something goes wrong, you're all in this together. And believe me, if they think you're not a very nice person and difficult to work with, the finger pointing doesn't take very long. Is the EMR your friend or your adversary? Is it making your practice safer? Is it making your practice more efficient? Is it frustrating you? Have you been given to copy and paste without making sure that what you're copying and pasting has been independently verified and in fact is accurate? If and when you're on a medical staff and you're the subject of an ongoing professional practice evaluation or a focused professional practice evaluation, are you taking them seriously? Are you listening to peer input? Are you truly engaged during your M&M conferences, or do you treat it as a formality and just a barrier to you getting back to the clinic because you have a whole group of patients that are waiting and you don't want them to be late because then you might have to rush through and, oh, by the way, I have a case in the OR at 3 p.m. and I got to have lunch before then. All of these things exist for a reason and you need to embrace them. Judgment. How much autonomy do you have? And I use this analogy, and I think you want to think about it. You are subject to guidelines, policies, rules, and regulations. Do you have more autonomy when you're treating a patient? Or does the pilot of an F-16 in patrol over the Pacific have more autonomy depending on what they encounter? Just something to think about. You both have rules of engagement. Communication. You've all heard of disruptive physicians. The physicians who cannot communicate with members of the team, with other members of the department, or can only communicate with individuals who that individual physician believes is an intellectual equal, are disasters waiting to happen. We have to communicate with each other at every level with respect and with understanding and appreciation for the role that you play. The era of the physician who may be a brilliant practitioner but is impossible to work with is over, because multiple organizations have concluded that they present a risk to patient safety, if for no other reason than people simply don't want to work with them. Are you afraid to ask for help? A case may be referred to you, but maybe in looking at it, it's like, hey, yeah, I know I've got board certification, but I haven't done a lot of these. And this could be a really tough one. And maybe this is one to let go of and be honest with the patient and say, I'd love to treat you, but you really need somebody who's a subspecialist in this situation. Or maybe you can assist the subspecialist. Don't hang on to it if it's not in the patient's interest to have you hang on to it. If you're training, don't be afraid to ask for help. You will get into more trouble thinking you can do it and being worried about asking for help too often than if you simply ask for help when you think you need it. Because if you don't ask for help and something goes wrong, that's when the second guessing really will start. We talked about this. Are you taking on too much? Are you resistant to correct treatment practices that individuals have pointed out to you are either behind the times, no longer safe, or simply shouldn't be done anymore? Be open to change. I like this cartoon. And this is often what your patient is thinking. Again, no matter how sophisticated you may think they are. Which therapy would you prefer? Here are all the risks, benefits, harms. Here's where they intersect. Here's where there's not. Here's the statistics. So patient, I have to give you full autonomy. Now that I've told you all of this, you tell me what you want. And the patient is listening to you and is thinking, boy, this looks like quantum physics. Hey, doc, can you explain it to me? Yeah, I've been there. Maybe some of you have too. We've got to be there to help our patients guide and understand the myriad of decisions that they're going to be making and what each one of them means. And that takes time, and nobody has a lot of time, but otherwise it becomes a mental mess for the patient. Okay, let's talk a little bit about malpractice insurance, because every once in a while something may go wrong. There are three types of companies in general. General insurers, you see them advertising on TV all the time. Physician-owned. Sometimes you refer to them as a physician's inter-indemnity trust or a physician cooperative. Self-insured entities like the University of California. The University of California is self-insured up to a certain level, and then after that it has reinsurance through general commercial liability entities. Big companies are often like that. Once you know which kind of insurer, then there are certain types of policy. There's a claims made policy. That policy gets triggered or implicated if the individual is insured at the time the claim is made or the suit is filed. So if you didn't have insurance at the time the claim is made or the suit is filed, this one doesn't cover you. When companies write such policies, they know 95% of their exposures within 5 years of receipt of the premium and 99% within 7 years. And then there's something called an occurrence policy. And that's generally how the University of California works. That policy comes into play if you were insured at the time of the incident. So if the incident occurred in 2019 and you're sued in 2025 and you're covered under an occurrence policy, you have insurance. This comes into play. Sometimes there's a long latency period. We have had foreign objects that were left in at other facilities that we discover 7, 8, 9 years later. It's weird. Who knew? If there's an occurrence policy, the insurance companies know 95% of their exposure within 10 years and 99% within 12 years. You can contrast that and you can see the latency period, and you can guess which kind of policy insurance companies prefer to write. One of the things that medical school and even residency generally doesn't prepare you for is something that I like to call the business of healthcare. Healthcare is an,
Oops,
yeah,
sorry.
go ahead.
We transition to this point. It's about the types of policies. So if I am a doctor who is now looking to purchase my own malpractice insurance because, in not too many years, I won't be under the shield of, an academic institution anymore. Where do you shop for this? Literally, where do you go to purchase insurance?
Yeah, you go to an insurance broker.
Okay.
I kid you not. If you're joining a group practice, you'll probably be covered by the group's insurance. But if you're going to open your own practice, there you can go online, medical malpractice insurance brokers. There are a boatload of them out there. And they'll get you connected with the company. They'll get you a quote based on your specialty, various deductibles or self-insured retentions, and you will be able to buy medical malpractice insurance.
Noted.
Who knew, right? Yeah, no, it's out there. It's just like people, well, nobody buys individual health insurance anymore, but if you needed an automobile policy or anything like that, different entities specialize in different things. Any other questions before we go into the business of healthcare and the stuff that really keeps people like me up at night?
I haven't seen any questions come in the chat, but this is a call to all of our participants. If you have questions as we're moving through this, because this is very new information to most people, then just drop them in there and unmute yourself.
Great, thanks. All right. Generally, physicians don't get into the news for malpractice cases. But oh boy, do you get into the news for the business of healthcare. And the Department of Justice loves the business of healthcare. They have pharma under a microscope. This was a news release from about a year and a half ago, where the insurance commissioner sued big drug manufacturer AbbVie, does a lot of biotech, for illegal kickbacks in promoting a drug called Humira. You're all familiar with Humira, not going to go into it. And the kickbacks are these things called payments, and it's not the obvious pay for play. It's the more subtle things. And if you look in the second paragraph, it included classic kickbacks, cash, meals, drinks, trips, and more sophisticated ones like free and valuable professional goods and services to the physicians. And sometimes it was going to the physician's advanced practice nurse to induce and reward internet Humira prescriptions. There was just a lot of it going on. And you will get people interested in you, and they will go after you. And sometimes that will be the U.S. attorney. Sometimes it will be the government, meaning the state government. Sometimes it will be things called relators, which are private lawyers who represent whistleblowers. And the whistleblower can be somebody who is in your office, and they will file lawsuits. And you will read about in the newspaper something called qui tam, QUI and then TAM. And what qui tam means is that a private lawyer found a client who said, I'm seeing the emails between company X and the nurse practitioner in my office where the drug rep is taking him or her out to an expensive meal. And all of a sudden, the number of prescriptions of that drug manufacturer's product is just going through the roof. And the lawyer will file this complaint. It's called the qui tam complaint. And then the government has a chance to intervene. And that's when Money and potentially freedom are at stake. So what is this anti-kickback statute that we hear about? It's a federal law. Sorry, I was on the button too hard. It applies to all participants in a transaction, okay? So that means the person paying the kickback, and paying I'm going to put in quotes, and the person receiving the kickback. It's not just the payer who gets into trouble. The kickback statute makes it a crime, and these words are important, to knowingly or willfully offer or receive remuneration for referrals, solicit referrals, or pay for referrals involving any federal health care program, Medicare, Medicaid to the extent it has federal money, Champus and TRICARE. These are all federal healthcare programs, which means it applies to a chunk of healthcare in the United States. There are state anti-kickback laws, and they will apply to a broader array of both state programs and potentially private transactions. Remuneration includes kickbacks, bribes, rebates in cash or in kind, directly or indirectly. The day where you are sitting at dinner and somebody slipped you $500, the schemes are not nearly that are not nearly that blatant. They are very sophisticated. And they're hidden in service agreements that pay people extraordinary sums of money to deliver a lecture. Or they will fly you first class for a 1-hour presentation at an exotic location and then allow you to stay for a week in the resort. In an era of computerized prescribing, it is very easy for authorities to track payments, remuneration, and prescription patterns. So what are the penalties if you violate the statute? Oh, you could go to jail for up to 5 years or get a fine of up to $50,000 per violation. So what would be a violation? You get the remuneration and you prescribe the medication once. That's one violation. Second time you prescribe it, it's another violation. Stuff adds up. And it adds up because the government does not want people incentivized improperly to use things that it pays for. In its own way, it is trying to protect the fiscal integrity of the United States and all of us as taxpayers. So, company, you can market your product, you can educate about your product, but don't pay people to do it. And providers, you can get referrals from whomever you want. Educate everybody about how great you are. But if it's going to be Medicare patients, woe unto you to do anything in terms of gift giving or anything else that could be considered paying for referrals. If you violate the anti-kickback statute, you in all likelihood will be excluded from Medicare, Medicaid, Champus, etc. Good luck getting medical staff privileges if you are excluded, or as it's called, debarred from federal health care programs. Will be extraordinarily difficult. In addition to the above, there are possible civil monetary penalties. These aren't penalties that are criminal in nature, but they will cost an individual or a company a boatload of money. So when you read about a major drug company settling kickback allegations with the federal government and paying usually tens of millions of dollars, it's because of something like this. Now, there are exceptions, but these exceptions only come into play if all of the internal requirements are met. And that's why some healthcare lawyers get paid a boatload of money, because they need to design transactions that are completely legal and do not run afoul of any of the healthcare laws and regulations of the United States or any state. And you will see some of these things are kind of technical, and it's easy to get hung up. Employment contracts, for the most part, they've got to be bona fide. They can't be illusory. Personal service agreements. Employment is generally full-time or part-time. There's a fairly clear agreement, but you can have personal service agreements where you're employed by entity A, but you're going to do one-time projects or certain things for entity B. Again, if you meet all of the requirements, you can enter into personal services agreements. Sales of a physician practice. I mean, if you think about it, what are you doing when you buy a practice? You are buying, I mean, technically the goodwill, but you're in a way, you're buying patients, okay? That's why physician practices are valued, because assuming you keep all those patients, what's it going to be worth? So you can do it, obviously you can do it, but it has to be structured a certain way. There's certain discounts that are allowable, but again, it has to meet certain details in structuring the discount, because the federal government doesn't want you to be using discounts for something, service A, so that you can then ring up the charges on service B that the government is going to pay for. So again, discounts can be employed, got to structure it right. Office space and equipment rentals, including land leases, got to structure it correctly, but physicians can lease office space from each other. It obviously happens all the time, right? You have physicians owning space in physician-owned office buildings, on physician land, things like that. You got to structure it right to avoid having it appear that it is a commercial transaction who has as one aim, doesn't even have to be the primary aim, but as one aim, the referral of patients. And if that weren't enough to give you heartburn, the federal government also has something called the federal self-referral prohibition, or as some of you may have heard, the Stark Law. The Stark Law prohibits physicians from referring a Medicare or Medicaid patient for approximately 19 categories of designated health services when there exists a financial relationship between the referring physician and the person or entity to whom the patient is referred. And when they talk about referring physician, that includes the physician's family. Okay? Very important. Because people say, well, I'll put something in the name of my spouse. You don't get to escape. But like for the anti-kickback statute, there are exceptions and safe harbors. For our purposes in this conversation, there are 4 relevant ones. There's the academic medical center exception. Obviously, physicians at UCI cross-refer to each other all the time, and we're all part of the Regents of the University of California, and we're able to do that. There are external HMOs. Kaiser is another one. The Permanente Medical Group cross-refers within itself all the time. It's perfectly okay. It's structured according to the law, and academic medical centers meet certain criteria also. Personal services, just like the anti-kickback statute, you can enter into a bona fide contract for personal services. There's certain ways of getting indirect compensation. Again, it's got to be structured correctly, and you can avoid the Stark prohibition. And then, of course, if you're a bona fide employee, you can avoid the Stark prohibition because physicians have ways of getting productivity bonuses, things like that. All four exceptions, including with anti-kickback, require the following principles be adhered to. The compensation arrangement must be consistent with fair market value, and it must be commercially reasonable. That's not the same thing. For example, let's say the fair market value for being the medical director of an outpatient surgery center is $250 an hour. Fine. But let's say the contract is for 80 hours a month, 20 hours a week. Is that commercially reasonable? Does the physician, especially if the individual is in a position to do cases at the ambulatory surgery center and generate revenue for the ambulatory surgery center, does that physician really need 20 hours a week to be a medical director? Usually not. Maybe 5 or 8 hours a week. So a compensation arrangement that had the right hourly rate, but the wrong number of hours, would be considered abusive because it is not commercially reasonable. And even if you meet all the other legal requirements of that agreement, it would not be considered a regulatorily sound agreement because it did not meet the commercial reasonableness test. That comes into play with the leasing of office space also. The price per square foot can be fine, but are you leasing more space than what you would reasonably be expected to need, both immediately and in the future? If you really think you're going to build your practice out and you're leasing double space, even though much of the space is fallow, okay, well, maybe you can sell that. But do you need 3 times the space, 4 times the space? Could be considered an abusive lease. It cannot be determined in a manner that takes into account designated health services referral volume or value. You will see that phrase everywhere, that this agreement does not take into account business generated or the number of referrals or the volume or value of those referrals, because we are not allowed to consider in entering into these agreements how much money we can make from the federal government. All right. Now, you're probably looking at me and saying, well, wait a second. Nobody's going to enter into an agreement without looking into that because we don't want to enter into non-profitable agreements. The key is the contract cannot consider that. In other words, the contract can't have a statement that says we're going to pay you 20 hours a week, $250 an hour, assuming the volume of the surgery center remains at X level. Because your compensation is now directly tied to the amount of business that is being generated, and it will be perceived as potentially abusive. The last section I'd like to talk about when we get into the business of medicine are things called reports to the medical board when you're out there practicing. And those are generally covered by Section 805 of the California Business and Professions Code and Section 805.1. There are other sections of the code that require certain reporting when there are issues about potential sexual violence or sexual harassment. We're not going to get into those right now because they have a number of requirements. They have a very short reporting leash. And if we get into something like that, it's usually the entity will know exactly what to do. So a report to the medical board is required when a peer review body, peer review can be fairly broadly defined, and a lot sometimes depends on the hospital bylaws, denies or rejects an application for medical staff privileges for a medical disciplinary cause or reason, meaning they're rejecting it, not because you don't have enough experience or not because you don't have enough malpractice insurance. Those are administrative, or you failed to meet criteria. It's when they think, we don't want Dr. Jones on the medical staff because we don't think Dr. Jones is a very good doctor. That doesn't happen very often, but it happens every once in a while. And if the medical staff does that, it must be reported to the California Medical Board, and the board may then investigate it. Now, individuals who have medical staff privileges denied, where a report would be generated, have things called fair hearing rights, where they essentially internally appeal what went on. But by and large, not a good thing. You get reported to the medical staff when the peer review body terminates your medical staff privileges, or whether your employer terminates your employment for a medical disciplinary cause or reason, which means when you have done something which makes them think you're not a good physician. When your medical staff privileges or your employment are cumulatively restricted by the hospital or by the employer for 30 days in a calendar year. Now, these 30 days can add up, because let's say you get suspended for a week because you're behind on charting. Well, there goes 7 of those 30 days. And let's say you're kind of a recalcitrant physician who just can't get their charting done in the time period that the bylaws prescribes. That 30 days can creep up on you. So you don't want that to happen, because that will get a report to the medical board, and the medical board will investigate. When you have been summarily suspended from your medical staff privileges or employment for greater than 14 days, summary suspension occurs very rarely. I think in my 20 years at UCI, it's occurred twice. For a summary suspension to occur, the chair of the department or the chief medical officer, the president of the medical staff, or the CEO of the hospital has to conclude that the practitioner represents an imminent danger to the health or welfare of a patient. This can occur, you read about this, hasn't occurred at UCI, when an individual would come to work intoxicated. When an individual could come to work potentially under the influence of substances that they have abused. It can occur when a review of a practitioner indicates that there is a very high complication rate, an unacceptable complication rate, and people don't feel comfortable with the practitioner doing that procedure anymore. Now, a lot of water has to go under the bridge before you reach that stage, but it can happen. And if that suspension remains in place for more than 14 days, it must be reported to the medical board on day 15. Now, the suspension is subject to appeal, but this is one of those situations where the report goes in before the appeal is final. And that's because the board takes a summary suspension very, very seriously. And at this point, I will stop sharing and I am happy to take any questions that you might have.
I think Reese and I got our few questions in as you were moving through the slides, but if any of our participants have questions, you definitely have time to ask them. Generally, it's always really good to have this talk because while it's not so typical for topics that we would cover in the world of health policy, I think it's just necessary that if we're going to be, leaders in this space and truly want to be knowledgeable about all that that entails, I think understanding the legal ramifications of your leadership are important too, right? So that's why this talk is here, and that's why it's situated within the Advanced Health Policy elective. But we're definitely here to answer any questions that y'all might have about the topics covered around malpractice, around the cases that were presented, around the business of healthcare and how that tends to affect providers in the legal context. So let us know. Yes, and as always, our feedback survey is live, so please give us feedback about this session. We want to know your thoughts.
Okay, if there are no questions, if something comes up afterward, I am at UCI. You guys can feel free to email me at any time. Good luck with your careers and be careful out there.
Thanks so much for being with us, Pete.
Anytime.
Appreciate it.